I think our attendees are slowly joining us. Good afternoon, everyone, and welcome to the webinar, which marks the expansion of the Judiciary Hub. The Judiciary Hub has been launched for the first time last year under the Reconstitution Program, which Democracy Reporting International is implementing with the funding from Stiftung Mercator. And now we have an opportunity to expand the Judiciary Hub to 7 new countries. These countries are Albania, Bosnia and Herzegovina, Kosovo, Montenegro, North Macedonia, Serbia, and Moldova. And we were able to do this with the support from Konrad Adenauer Stiftung. And we are very pleased to have with us Dr. Pavel Usvatov, who is the director of the Rule of Law program for Southeast Europe for Konrad Adenauer Stiftung. And we would like to, before we start with the event, we would like to give him a floor for a few sentences for introductory words. Please, Pavel.
Thank you very much, Nino. And welcome, and it's really nice to see some names that I already know, and also some people who worked on this project also from our side among the attendees. And it was really a nice opportunity and a pleasure for us to support you. So thank you very much for inviting us to partner up in that regard. Our rule of law program is working in the whole region here in Southeast Europe, which is quite a complex story. Actually, it's a very small region but very diverse, and as you will see also on the hub, also regarding the judiciary, there are many challenges. It's a very dynamic region that changes a lot. And what is actually quite interesting to observe, something that never happened in other European countries that have been democratic countries for a long time, is specifically the vetting process in the judiciary, like in Albania, now going on in Moldova, also thought of in Kosovo and some other countries. Montenegro, for example, is discussing this, an attempt to clean up the judicial system from the remains from the pre-democratic time, but also from corruption. And I think that it also reflects in the numbers that you can find also on the hub, but I don't want to say too much about this because Nino will present it more deeper, and I'm really looking forward to the discussion which will take place also today. So thank you very much for partnering up with us. We are very happy to support the project. We will stay on board, and I hope that we will also expand the data, deepen the data, and that this hub will also be a success story for everyone who needs the information about the region, about the judiciary in the region, and keep updated. And just a very small announcement, in the very end of this call of this presentation, I will ask for 1 or 2 minutes of your attention to present our blog, which is also indirectly connected also to the hub, because the idea came up with the same time actually with the hub. Okay, thank you very much, and I will give back to Nino.
Thank you very much. We look forward to also hear about the blog. But before that, I will explain in a few words how we'll proceed. So I'll start with a short presentation of our thinking behind the hub and how it came about. And then I will also demonstrate on the screen how it works and what are its features. And then we have 3 fantastic speakers that we will have a discussion with regarding the challenges of that the judiciaries are facing in these countries that we have expanded the hub to. So let me share my screen with you so that there will be a really short presentation, and then we can quickly move to the most interesting part, which is a panel discussion. So we I will kind of be reflecting on a few things. So why did we focus on the judiciaries? That's the first one. And then why did we decide to do it in the form of a hub? Then why did we expand it now? And what are our objectives and functions of the hub? So why judiciaries? The research really shows that democracies are most resilient when there are strong judiciaries in place that can impose constraints on the political branches, and due to this, these judiciaries are often subject to attacks. The politicians have tried to capture the judiciaries or weaken them or disregard their rulings. So there's a lot of problematic rhetoric and measures around judiciaries in the EU and in accession countries. So at the same time, we see issues that are internal to the judiciaries in addition to the external attacks from politicians. These includes internal hierarchies that are so well entrenched that they really lock in problematic culture inside the judiciary. This could include corruption and inefficiency, and all of this really shapes public's and individuals' experience with the judiciaries. So we thought this is also another aspect that is very important to cover. So for these reasons, we really try to bring this knowledge together. Why the hub? Why did we create such a resource or wanted to create such a resource? There's a lot of data on the judiciaries. That's very true, but this data is really dispersed in a variety of fora, variety of indexes, articles, reports, research, etc. So we wanted to bring all these sources together in one place and also make the developments easier to follow. As Pavel rightly mentioned, this is a very dynamic field and a lot changes from day to day, and it's very hard to follow. So that was another reason, another issue that we saw that we wanted to address. Of course, then another thing is that the language that's used to talk about these topics is extremely legalistic and technical. And we want people and we want journalists to talk about these topics. And this is not the language that they are using. So that was another aspect, another sort of issue that we wanted to address. And also another thing is uneven coverage. Some of the countries receive more attention, others less attention. So we wanted to bring together knowledge about all the countries in the region and also address a lot of the misleading statements and half-truths that are voiced regarding courts a lot of the time. So essentially what we try to create is a one-stop shop, one place where you could go and learn about the judiciaries in an organized manner. Of course, a lot of the sources are coming from other actors. For example, World Justice Project's Rule of Law Index, we picked out certain data points that are relevant for the judiciary. Various other surveys and indexes from Transparency International and many others. So also academic articles, but we also try to create original data on this. This includes our analysis of challenges, but also the data, for example, on the non-implementation of European courts rulings. That's a study that we do together with the European Implementation Network. We work on the Court of Justice of the European Union, and our partner is working on the European Court of Human Rights, which is particularly relevant for the countries in the region that we are talking about today. So we also tried to create in a more accessible format and also cater to the audiences with different levels of experience. We wanted to help somebody that is coming to the hub and doesn't have understanding, for the first time covers the judiciary, for example, as a journalist, versus somebody that is more experienced and needs something more in depth. So we also wanted to inform reform discussions and also to kind of draw attention to some of the issues that don't get enough coverage. So why did we decide to broaden the coverage to the accession countries, some of the accession countries? So we wanted to create one place where all this knowledge is accumulated, and also we thought that there's a two-way possibilities of learning. On the one hand, the accession countries can learn from the European Union member states' experience, but also reverse what we see that the accession countries, judiciaries there are under significant pressure. This is something not very common, wasn't very common until recently for EU member states, but we see it increasingly there as well. So this is the area where these judiciaries could actually learn from each other. So another reason why we wanted to expand the hub was to further support this evidence-based, fact-based analysis on judicial performance and also facilitate more comparisons within the region and across the whole EU and accession space, accession countries. So these were the kind of main, this was the main thinking that we had in terms of conceptualizing the hub initially, as well as to when we decided to expand it. And there are a few things about the hub that we want to highlight. Obviously, I will go in a second into the actual hub and show the particular features. But you'll see that we have a map and various country profiles, various other functionalities, such as the comparison function and glossary, etc. So in a second, I will now share my screen once again to show some of these features and show how essentially it can get quite interesting to see the hub and how it could actually be used. So here we have the hub. Let me see if I'm able to. Yes, so this is the main function of the hub, which is a map. So on the left side, it is possible to see a variety of parameters, and then we should be able to compare states based on these parameters. For example, the number of judges per 100,000 inhabitants. It's quite interesting. So if you take a look at the region that we are adding, we will see that Albania is marked differently. It signals that Albania has one of the smallest number of countries and judges in the region per 100,000 inhabitants. And I believe that this is data that doesn't incorporate yet the reduction in the number of judges through the vetting process. I believe the number is even lower now. And there are many other parameters like budget per inhabitant, how well the judiciaries are funded in different countries. So we see EU member states, but we see also that in this region, Albania is one of the least well-funded states, as well as North Macedonia in terms of the budget per inhabitant. As well as Moldova, the same applies here. Then another interesting aspect is the gender balance in courts, for example. We see here that in almost everywhere in the EU member states and accession countries, the judiciaries are more female dominated. There are more women in judiciaries. But if we zoom on Supreme Courts, you will see that in most EU member states, the judiciaries are male-dominated. Supreme courts in particular, are male-dominated. So it's quite an interesting thing to observe. Then another interesting element we could compare the countries based on is the judicial governance model. You can see that essentially there's not one model that is accepted across EU member states. So there are a variety of them. So even within the judicial council model, model defines who decides on important things such as judicial appointments and finances related to the judiciary, etc. So we see that judicial council model has several types of judicial councils, and then we have other models such as court service model in more Scandinavian countries and Ministry of Justice model in Germany and Czech Republic as well, and Austria. So there's a variety, and then it's quite interesting that a lot of the accession countries adopted the judicial council model. We can see some of them adopted the strong and others adopted the moderate judicial council model. So it's quite interesting. Was it a success? Was it a failure? How it worked out? That's something that we will also be asking our experts. Another aspect is that the map incorporates all the surveys and indexes on the topic. And for example, with the judicial corruption levels. This is based on the World Justice Project. If we mark it, we see variation across EU member states and across the countries that we have recently added, accession countries. And it is possible to see how the picture, at the bottom of the page, you can see how the picture was changing across the years and how the countries were kind of improving or deteriorating based on this parameter. Then for the accession countries, another interesting aspect is how they implement the European Court's rulings. And in this particular case, for the accession countries, European Court of Human Rights. So here we see what the variation is. Even within the EU, we see that Italy, Poland, Hungary, Romania, and Bulgaria have a really very serious problem with their record with implementation of European Court's rulings. This is the Strasbourg Court. And if we zoom on some of the accession countries, we see their performance varies also between moderate and problematic. So it's quite interesting to see the variation as well. And final feature of the map is the challenges. So if you are interested in how the states are faring with respect to particular issue, for example, slow judicial proceedings, we can see that a lot of the accession countries have issues with the slow judicial proceedings, but also some of the EU member states do as well. For example, Italy, Portugal, Poland, etc. So this shows more a broader picture. There are several other challenges, but this is not an exhaustive list. Each country profile that I will explain later has its own list, more extensive list of challenges that you can look at. So if one presses essentially a country, it's possible to see the short profile of the country, and then it leads later to the long profile, which is available here. So for example, short profile is this one, and then we can go to the long profile as well here. So Bosnia and Herzegovina, for example. And within the country profile, it's possible to see different sections, basic facts, who decides on the judiciary and what kind of distribution of responsibilities is within the judiciary in terms of key decisions such as judicial appointments or discipline or similar promotions or many other issues. Then we have other sections as well. If we scroll down, challenges, and here's a complete list of challenges already for the country. Some of the positive developments, and then rankings and surveys. We can see if we mark a value that we want to assess country against, then the index, then we can see the visual for a particular parameter, for example, integrity. And if we look at indexes, and for example, we have option Transparency International's corruption perception index, then it will show us how this country evolved over time. Of course, these are external sources. And then we have expert recommendations outlined here with respect to the particular country, and then the performance in terms of compliance with the European Court's rulings. Here we see that Bosnia and Herzegovina's performance is moderately poor, and this is calculated based on the three parameters that methodology was developed by our partner, European Implementation Network. So specific rulings included here as well, and also any further readings if somebody wants to dig deeper and learn more about particular aspects of what's been written about the judiciary on this country. Another key feature is the comparison feature. For example, you choose the variable, and then you would choose the country, maybe two countries, for example, Albania and Moldova. And then it's possible to compare based on variety of parameters like financial resources. We see here that Albanian judiciary gets a little more money than Moldovan judiciary per inhabitant. So this is another feature, then the glossary, where certain key terms are explained. This was to make sure that these technical terms that I mentioned in judicial governance, magistrate, Ministry of Justice model, these are explained. to the person that checks out this hub. So this is for the most part it for the hub. I guess we can stop here with the presentation and use this opportunity also to talk to our three fantastic speakers that we have today with us. We have Beba Zagar, who is a researcher with the Democracy and Rule of Law program at the European Policy Institute in Skopje, North Macedonia. She publishes a lot of policy briefs about which we'll also talk later, and also contributes to a variety of other reports like the annual shadow report on chapter 23 that was published by the European Policy Institute, and she engages in a variety of other activities. And then we have Arlene Puka, who is a legal specialist, and he focuses also on democracy and the rule of law. He's currently a consultant for Raoul Wallenberg Institute for Human Rights and Humanitarian Law, and supports the Ministry of Justice of Ukraine on Chapter 23 and EU acquis, focusing on justice, judiciary, and fundamental rights. And our third speaker is a journalist, investigative reporter Bojana Jovanovic, who is also deputy editor of CRIC, that's a Crime and Corruption Reporting Network. We are very pleased to have you with us and to hear your thoughts about a variety of issues related to the judiciary. I will start with Beba. Beba, you last year you prepared a brief using the Judiciary Hub, obviously other resources, to reflect on experiences of EU member states on the judicial governance, and also how it's reflected in North Macedonia. And I was wondering which features, how did you use the hub, how did you find it, and also what have you learned from it in terms of what candidate countries can learn from the EU member states in this respect?
Hello, Nino. Hello, everyone. Firstly, thank you so much to the Democracy Reporting International for the invitation to speak at this webinar. It was a great pleasure for me when you invited someone from the European Policy Institute, because the Judiciary Hub was very useful for me, not only during the writing of the policy brief you mentioned, but in general for myself and for my colleagues for our research activities. So firstly, a little bit of history. When I used the Judiciary Hub platform, it did not include the enlargement countries. But nevertheless, it had all of these useful features, which, Nino, you already mentioned and explained during your presentation. What especially stands out in this platform, I think, is the comprehensiveness of information and of sources included. So when you look at the country profiles, when you look at the map in its entirety, it's very useful for researchers and legal specialists to conduct their research and prepare reports and analysis. My policy brief was regarding the judicial governance models used in Europe. I say Europe because I had a comparative analysis of eight EU member states, but I also included North Macedonia since it's the country where I come from. It was very useful to see through the platform this feature which you mentioned, the comparison of the countries. When you compare two countries, three countries, which models do they use? How are these models perceived by their own citizens? And do they enjoy the same or different levels of independence depending on the judicial governance model implemented in each of the countries which I analyzed? My findings came to the conclusion that there is no ideal judicial governance model. Yes, I see your hand raised.
Please continue. It was
Sorry,
a technical
I
error.
thought that I was beginning to be too long. Sorry. There is no ideal judicial governance model. So the model used is a set of regulations, a set of rules, which governs the manner in which the judicial branch exercises its function to implement the laws to concrete cases. But when you look at the three most used in Europe, so the Judicial Council, the Court Services, and the Ministry of Justice models, you can see that each of those has some sort of an issue. This is generally the intrusion of the executive branch in those institutions. But there are also other issues which have been indicated in several EU member states, even though these models have been implemented for many years, so they are not new models. Even in North Macedonia, the Judicial Council as an institution was introduced in 2005, and 2 decades later, we still identify many issues with the institutions, such as political pressure, undue influence, lack of financial resources. So the general conclusion would be that we have still much work to be done, but these comparative analyses, I think, serve a lot to see what we should be doing in the future.
Fantastic. I wanted to maybe dig deeper a little bit because you already mentioned some of the challenges for North Macedonia in terms of political influence or lack of resources. I wonder what are the main, in terms of judicial independence especially, what are the main barriers? Where is the problem? Is it a law? Is it how the law is applied, or some sort of mentality and culture that's prevalent in the country? What are your observations on that?
So when looking at the judiciary as its entirety in the country, not only the Judicial Council, we have to mention the financial issue. So the legal norm is 0.8% of GDP should be allocated to the courts. But right now, for example, for 2025, 0.3% of GDP was allocated to the courts. This means that both courts, public prosecutors' offices, both councils, the Judicial Council and the Council of Public Prosecutors, face financial difficulties, which in turn influences the lack of human resources, or people that are employed lack capacities in order to implement all of the necessary reforms. There is a lack of technical capacities and, of course, unsuitable premises for conducting of the work. Other than the lack of finances and the lack of financial independence, undue political influence has been noted in the past several years. Even in the latest country report published by the European Commission, there were different instances of, let's say, pressure or slight meddling from the executive branch. There have been statements from high officials, from government officials regarding the Judicial Council and members of the Judicial Council, which were perceived by the Council as pressure and meddling in its work. Other than that, there was an interpellation by the parliament. The MPs voted no confidence for some of the members of the Judicial Council. This is not, according to our legislation, this is not a legal ground for their dismissal, but nevertheless, it affects the work of the Judicial Council as well as the citizens' trust in this institution. There have been another example of this sort of pressure was the fact that the parliament did not approve the annual report of the Judicial Council for 2023. So we see that we have an issue with the separation of power. The role of the judiciary is to serve as a corrective of the executive branch. And here in the past few years, we see a different story, a pressure of the executive branch over the judiciary.
I wonder, in view of these reports, how resilient do you think judiciary is, and what is necessary for it to be resilient? I mean, the fact is that resilience is only tested if something is under pressure. So it's a good lab, a good testing environment to see whether judiciary is actually resilient. What do you see, what do you observe in this respect in terms of responses to such kind of pressure?
So far, I've noted generally negative developments in the judiciary and in its relations to the other branches of power. It should be noted that there is a new strategy for development of the judiciary from 2024 to 2028. The implementation rate for last year is just above 40%, which is a good level, a good rate. There is let's say an effort, a serious effort from the institutions, not only inside the judiciary but also the Ministry of Justice, to improve the situation in terms of legislative amendments which have been recommended by the EU peer review mission. And then the Judicial Council also tries to work. For example, last week I was just at promotion of the new program for combating corruption in the judiciary. The program is prepared by the Judicial Council. It was promoted with the citizens, the civil society sector, and experts from the legal sector. So we have examples of the institutions working against these pressures and working towards the very needed reforms in this area in the judiciary. But we still have to see what happens, not only with the council, but in general with the pressure the judiciary is facing.
Thank you very much. I was wondering maybe more like a forward-looking, future-looking question, or maybe first we have to look into the past, then in order to really look into the future. I was wondering, in the hindsight, what should have been done differently, and what would you change now? What are your recommendations in terms of improving the situation with regard to the judiciary?
So, yes, I believe you're correct. We should look at the past for a little bit. I mentioned that the Judicial Council was introduced in the country with the Constitutive Amendment in 2005. We were one of the first enlargement countries, then a candidate country of the European Union, to introduce this type of institution. So what was seen as a pioneer move 2 decades ago, now we see as an institution which is deeply damaged, and an institution that does not enjoy the citizens' trust. I think we need to look at what were the past sort of acts, the past decisions, the past manner of composing, the past compositions of the Judicial Council, and the past interactions of the other branches of power with the judiciary, in order to see what we can learn as lessons from the past and what we can implement in the future. Of course, what we mentioned in the beginning, a sort of comparative overview is also important. We need to see what we can learn from EU member states, which also employ this type of judicial governance model. And of course, our neighbors from other enlargement countries, what do they do, what we should do in the future. We definitely have to increase the budget which is allocated to the judiciary in its entirety, not only to the council. We need to look at the Academy for Judges and Public Prosecutors. They're the only entry point of judges and public prosecutors in the judiciary, but they do not have the financial resources for new candidates. So we need to work in this area as well. There have been some inquiries from the judges to increase their salaries. We need to look at what we can do for not only judges and public prosecutors, but also the court services, the administration, which is also dissatisfied with their salaries. We need to increase their capacities and the technical resources which they need in order to perform their work more independently and more efficiently.
I can see, yes, it's kind of, it also raises, it gives me an impression that being a judge doesn't seem to be a particularly attractive option for lawyers in these countries, which is something that definitely needs addressing, and also the educational and training systems as well. Yes, thank you very much for your reflections, Beba. It's always great to hear from you and learn about your work. And now we will go to our next speaker. I want to ask Boyana for her reflections on a number of issues. I think I wanted to start with this question of how do you see the role of media in securing judicial accountability? You work on corruption issues, and sort of I think it's very much plays into your work to see what media can do to hold them accountable.
Yes, thank you so much for invitation, and it's really honored to be part of this panel and to share the impressions and all the problems, I would say, that are related to judiciary in our countries. So I can say that CRIC is basically the pioneer in Serbia when it comes to calling judiciary for accountability, because what we faced when we started reporting about the judiciary and about all the main cases about organized crime and corruption is that judges weren't really friendly. They are still not really friendly, nor judges, nor prosecutors, because I think that in Serbia we inherited something from probably from the communist time, the thing that the judiciary is basically hidden, that the judges and prosecutors, they are people without that are hid behind the institutions, people without names, people who don't like to be mentioned, who don't like to be approached by journalists and asked anything. So I think that we were among the first media in the country that started actually reporting really on judiciary. And when we report about court cases, because we are covering the main court cases, for example, we always mention who are the judges who are making decisions in those cases. And that is something that was really new, and that we actually changed kind of the media situation here, because then other colleagues also followed the narrative, and they also started reporting in this way. What we also do is that we started writing kind of analysis of the cases, of the verdicts, of the decisions that judges brought, but also giving the context in the society, in the country. So, we would explain why some verdict or some decision was brought in this moment, in this particular moment. Why is it important? But also, who is the judge or prosecutor? Who is the person behind? Who is the person who signed the decision? Because then we could see if there is some scheme or if there is some pattern that is interesting for investigative journalists, to follow up and to see what is really going on. And while reporting about this stuff, we basically get one, I think, still really good idea. That is to do the database of judges. So that is something that was really new, and for Serbia, it really changed, I think, the situation, but also the way people are thinking about judiciary and thinking about accountability. Because what we did, we basically started looking into the names of the people who are bringing the most important decisions in the country. So we wanted to show to the citizens in Serbia who are the people behind the biggest cases in the country, who are people who are bringing decisions, what decisions they are bringing, and in which other cases they also were bringing decisions, and what kind of that. So basically we analyzed first we started with the judges who are making decisions, who are basically members of the Department for Fight Against Organized Crime, because that's like those were the cases we were following and reporting on, like from the courts. So we basically made a profile for each judge, and that profile has biography, but like working biography, so we can show how the career of judge was building through the years, but also putting the context of the cases the judge did, and putting the context of also some adding information related to the judge behavior. Because, for example, what we also did is that we investigated who are, for example, if there were some complaints against judges, if there were some investigations against them, or like if they made if they act in a way that is not really something that you would expect from judge how to behave. So whatever we could basically to get whichever information we could get about particular judge, also the property, because as we investigate corruption, that was also one of the things to investigate, to see if judges can actually explain the origin of the property they have, and if their property is maybe bigger, more than the salaries, the income that they receive over the years. So then we could ask the questions, okay, how did you gain this property? So we would collect all this information and we publish the database. Unfortunately, it's only in Serbian, but we put all the important information about the judges. And why we did this? We did this because people deserve to know who are the judges, who are the people who are making decisions in the biggest cases. And also judges are public officials, which they often act like they are not. So they need to explain things to the public, and they need to explain some things to journalists, to citizens of the country. So this is how we basically tried to make judiciary in Serbia more transparent. And in some cases, if there is some like weird decision, to call judge for accountability and to see if some institution, something will happen after our publication. This database, I must say, brought us many problems, because it became really fast like the topic of debate in the society, because of course, as I mentioned in the beginning, judges are not really used to be mentioned in Serbia, in the media especially. So we got a lot of attacks, basically even from the Association of Judges in Serbia, because they were all saying that we are interfering and that what we did is not of public importance. Basically, the main what was the main problem for them is that they were saying that we are like analyzing the law, which we cannot do because we are journalists, which is not true, because we were just explaining the judges. And as you, Nino, said at the beginning of the webinar, the language is a huge problem. So because citizens, they don't understand the judiciary language, and that's the role of the media to change the language so everybody could understand what's going on. So basically, we were attacked, and we are still actually fighting for this database. I think after some time that judges and prosecutors changed their mind. So, for example, in the beginning, none of them wanted to talk with us while we were investigating. Then the situation changed, because they saw that it's not that scary and it's not that problematic, and that it's maybe even better, to explain the things, to answer the questions, because then everything will be clean and people can understand the things that we wrote. But unfortunately, we got also like 3 slaps from because we published one of the profile, because one of the judge of the appeal court in Belgrade, she's member of this department for fighting organized crime. She issued 3 lawsuits against us because of her profile. And she didn't mention, like in the lawsuits, she never said that anything is like what we published is wrong or untrue, but she wants her profile to be removed. And now basically we are fighting for actually the main role of the media, because our main role is to be watchdog of public officials, of democracy, and to report about things that are of public importance. So now we are basically fighting for the role of the media, because in the judiciary, because the judge claims that we cannot even publish her name. So if we cannot publish, if we will see, I mean, the cases are ongoing, so we will see what verdicts, what decisions will be made in these cases. But the judge she issued 2 criminal complaints. So she is asking for prison for journalists, including me, 10 months of prison and 2 years ban of doing journalism. So this is, I think, the best example of how judges, also I think prosecutors, some of them, how they look at media and transparency and public importance and things that should be really known to and published to citizens. So it's really, I think that we are currently in Serbia in a really, really bad position and bad situation, considering the situation in society. And that in current situation, it is really hard for the media to reach out to judiciary, to report about judiciary, and especially to ask for judicial accountability to do any progress there.
Thank you so much. I really didn't want to stop you because I find it really fascinating for many reasons. One is the project and how really it is an opportunity to change culture around judiciary. It is not unique to Serbia that judiciary feels very detached and public accountability is not something that they practice. At the same time, this is also important that they see it as an opportunity to legitimize themselves, because as also Beba mentioned, public trust is something that's rather low in a lot of the countries that we are talking about. And another aspect is also very important that you highlight is the difficult environment that the journalists have to work in. You mentioned the abuse of litigation. This is one of the probably most important negative tendencies of silencing journalists as a way to silence them if it works. So this is definitely something to be alarmed about. I want to go back to the public element of the public. I was wondering, in other countries I'm looking, public is not always interested about courts and learning about courts. So what makes a judiciary-related story a compelling one, and how do you think, what are main misconceptions that the public has, or how well do they understand, in your view, the issues that are present?
Well, that's always a tricky thing and tricky question, because yes, public is not really doesn't have trust in judiciary in Serbia, and I think it's something that is, as Beba said, is the thing that persists for years. So it's not something new. It's way of the also culture, because a lot of actually citizens, they don't they feel like in their own life they feel the consequences of judiciary that is not independent, and they like a lot of citizens here had some problems with judiciary. So they have also personal cases and they have experience with that. So they feel how big issue if the judiciary is not transparent and if it's not independent. But I think that it's media has the big role in this, because media is creating the narrative of and like media is creating the narrative of what's going on with judiciary, because we are the middle party between judiciary and citizens, because citizens I don't think that a citizen can really understand like the highest thing and what is really going on with judiciary, like in general. So we need to be there to explain to them. They can have their personal experience in like their personal cases, but when it comes to the general scene, I think that media has the most important role there. And the first thing that is, and the most important thing for media is public interest. So when we are reporting on judiciary and we are deciding if some topic is for us or not, if some topic should be reported about, is public importance. So if we can explain to the citizens why this something related to judiciary is important for their lives, how that can affect their lives or their future, then there's no doubt that this is the topic that is really important. And in this way, independent and investigative media has the biggest role, because for example, in Serbia, the media situation is also like really complex, and it's really sad that we have really divided the media market. So a lot of mainstream media are under control of the ruling party and government, and they're spreading their narratives. So it's really hard to get to the public, to the citizens, to get their trust, especially if we are reporting about judiciary. But what is, for example, because now we are living currently in Serbia in like really challenging times, and I think that's why our role is to explain to the citizens and so they know that independent judiciary is the most important thing for democracy and for our future. And we can see, I mean, we see what's going on here now, and what is in what shape judiciary is, because now it is so obvious that the political influence and the government influence basically took over the judiciary and trying to make it a mechanism for the repression that is currently going on in Serbia. And that's why it is really important to report about these topics and to report about why is it important for the future to have independent judiciary, and to explain to the people that actually they need to also be involved in this process, because it's really like we need to fight for democracy. So everybody need to have some role, and but like it's really hard to understand when citizens can start trusting to judiciary, because when they see what's going on, it's really hard for them to trust, and we need to fight for independent judiciary, so there can be public trust in them.
Great. This final question, I think you touched upon a little bit on this. I wanted to ask how difficult, what are the main challenges in writing about the judiciary? One is when you actually write about it and what kind of response you are getting. But in terms of process, I was wondering how could we make the task of a journalist easier as researchers, for example, or in general, what are the barriers? Is it the transparency? Is information that is hard to get? So what are the practicalities of it that we could address and make it easy for journalists to cover judicial related issues?
Yeah, I think in Serbia now the biggest problem is that institutions, like the system is basically collapsing, and all the institutions are captured. So it is really hard to get any information, whether we are sending a request based on the Freedom of Information Act, whether we are asking like questions as journalists, whether we are trying to approach to the people and to get some interviews or like any official statement or anything like that. So I remember that a few years ago the situation was also bad, but it was better than now, because institutions, especially like judiciary, they were kind of trying to open for public and for try to be more transparent. And now in the last few years, it's really getting worse and worse. So it's really hard to say. I think that we are facing challenges on each level when we try to get information, whether we are trying the information related to like a court case or like investigation that prosecution is doing. If we are reporting about what they do, it depends from the case to case whether they will give us information, because not because they're looking into the how sensitive topic are, but the political influence is really, really big. So basically they are deciding based on the political will of the ruling party, should they send some information to us or not. As I said, with this database, I think we touched this problem with judges that they don't understand the role of media, judges and prosecutors also, because I think people from judiciary look at journalists as like enemies. And I think that there is not enough trust between us and them. So that is one of the things we need to work on, because we are not there to prosecute them or something like that, but we are there, we have the same goal, or we should have the same goal, and that is wider transparency and democracy and better society in the end. And we need to work on this so the justice can be something that is really happening, and not the thing that people are just saying and dreaming about. And it's really challenging, but I think that we are now like, because now it's really hard, the current situation in Serbia, as I said, because everything is practically collapsing. So it's really hard to get anything from the judiciary. So it's really hard to report or investigate judiciary. But I guess that the situation will be like stable in the future months, so we can see, and if there are some changes with the regime, because now we are like really autocracy regime, so it is really hard, and the pressure is bigger and bigger on the independent and investigative media. So that's also a challenge for us, like in general. And I think that, like, I hope not think, but I hope that situation will get better. And in that case, the main things we need to work is to make some more like collaboration, or like to enter, to make some bridge between us and judiciary, because we should be on the same side, so they can understand what we do and why we do, if they don't, or to push them to follow the law. Mm-hmm. Because like if we have Freedom of Information Act, then it should be something that will help us and help citizens and public to get information and not to become the like mechanism for them to avoid to do anything. So, but it's really a lot of challenges, but political influence is the biggest problem, and non-transparency of the judiciary.
Definitely. Thank you so much. And really, we hope that you continue your work your very important work in this really complicated environment, but it's really something that requires a lot of dedication and courage. So thank you for your reflections. And
Thank you.
Now we move to our third speaker, Arlind, Arlind, I kind of asked you to reflect on Albania, even though I know that you have a very broad perspective and comparative perspective on courts in the region and in the EU. My first question has to do with, I will say, it's probably one of the most interesting questions about Albanian judiciary is the vetting experience and how what we have learned about that experience, because that's something that's also interesting for other countries in the region, but as well as for the EU member states, some of them. What are your thoughts in that? What are the learnings from this, and what needs to be factored by other contexts when considering vetting?
Sure, Nino. Hi, everyone. So thanks very much for the invitation, Nino, to you and DRI, and as well to Pavel and Konrad Adenauer Stiftung. So regarding to your question about the vetting, so much has been spoken about the famous vetting process in Albania. I would say that the vetting process helped in fighting the corruption, especially within the judiciary in Albania, as it was very much endemic and widespread in the system. It increased the public support overall, the level of public support for the independence of the judiciary or the work of the judiciary in general in Albania prior to the vetting process was at 4%. Currently, we are speaking about 47% of public support towards the judiciary. That's the Rule of Law Report 2025 of the European Commission as a data, but as well some reports that's usually the percentage that is fluctuating. Out of 802 magistrates in Albania, judges and prosecutors, 426 were dismissed, which is almost 60% of the total number of magistrates in the country, and majority of them couldn't justify their assets declaration. We have as well created with the justice reform a new special prosecution office, which is composed by 20 prosecutors, and it has a profile aspect for fighting organized crime and corruption. This special prosecution office in the recent years have been prosecuting 35 high-profile politicians in the country, which included former presidents of the republic, former deputy prime minister, and current deputy prime minister, current mayor of Tirana, former ministers, former MPs, and current MPs. So it's really, I would say, one of the main as well aspects that Albania has been holding 5 intergovernmental conferences with the European Union and opening all the chapters. I think very much a success. It's attributed to the work of this special prosecution office, which people very much in the country connects or liaise it as the whole part of the judiciary, but it's just 20 prosecutors, and it represents 0.3% of the whole judiciary. And of course, these I would say, and asset seizures in the amount of 130 million euros, but much more has to be done on the asset confiscation. However, these I would say are from the successes, but there are plenty of challenges that are connected to the vetting process. According to the Venice Commission, this was an extraordinary measure that should be held only once when there is a very high level of corruption within the system, and it is as well a costly process. To Albania, it cost $270 million as a whole process. Mostly the money came from the European Union and USAID, the majority of funding, but we would say just for one judge, it was estimated to be like the calculation around 10,000 euros as for the vetting process, the whole investigation, the whole case. So if it comes to the recommended, much has been spoken as well about in the region about the vetting process. Should it be in North Macedonia has been the case that the government wanted to introduce the vetting process. It was opposed coming from Brussels. So the European Commission actually did not recommend or publicly went into support of that process. As well, the judiciary in North Macedonia, it is not at the levels of corruption that Albanian judiciary had previously. In addition, as well, in Kosovo has been the case from the current government to introduce as well the vetting process towards judges. But for Kosovo, North Macedonia, we are really speaking about different approach, different levels of corruption compared to Albania. Albania had it very, very much endemic within the system. So I would say for other countries that are imposing, Moldova and Ukraine are at the moment currently going on with the vetting process, but I would lean more towards a no when it comes to the vetting process, because this in other countries of the region would lead very much to increase the political influence from the ruling parties in the respective countries. So for this, I would lean more to a no for the vetting.
So you are highlighting more risks in terms of the potentially another political capture. So from one problem to another in a way that we potentially highlight. And also one thing that you are mentioning is that there has to be a high level of compromise from all sides in order for it to work as well, plus the costs. So it's definitely probably why it is seen as an extraordinary measure. So it's something that you do last resort if all the other ordinary measures like disciplinary measures or normal criminal processes work. And those work if it's more isolated, if it's more systemic, then it requires a more systemic approach to it. One aspect that I saw being highlighted is that Albania is a very small judiciary and it got even smaller once the vetting process was carried out. And then the question is whether, I mean, the public is probably suffering, I assume, because probably they have to wait for even longer to have cases. So what is the thinking around this, do you think? And is there any resource how to approach to make sure the new judiciary doesn't have the same features as the old judiciary, because a lot of this is coming from the same systems, the same culture, the same educational or training institutions. So how to not repeat the same situation and mistakes?
Yes, and this, it's another question that the vetting process led to as well, capacity shortages. So in the country, there is a lot of vacancies to be filled in the judiciary. At the moment, there are 272 judges, and the country needs 150 judges more to somehow functionally operate. We are speaking about that it leads as well to the judicial proceedings to delay. For example, in a civil case, an Albanian citizen needs to wait for 7 years for a case. In criminal cases, it is 2.5 years. Or in the Court of Appeal, for example, there are 28 judges out of 78 in the general jurisdiction. And before the vetting process, for a case in Albania, you need 250 days. Currently, it is 1,250 days. So it's 5 times more delayed than it used to be to have a case verdict from the Court of Appeal in the country. Last month, as well, in the end of October, actually, it was as well a case where a judge was shot in the court hearing in Albania, which was a shocking moment, which never happened before, and it was about a case that it took more than 30 years to be resolved, and one of the defendants actually was acted like had that in a criminal way towards the judge. So these are like the extremities that might lead even the capacity shortages, and there was not a backlog fill plan how it should come. There was not as well legal clarity. So it was really an experiment that it was coming from the vetting, which led later to the increased number of cases and filling the vacancies. So, and when it comes to how the country is trying to somehow outcome this process, the number of candidates which are entering into the school of magistrate, that is the first entry point to the judiciary in the country, is 10, only 10 candidates. And we are speaking about the need of 150 judges to enter. And every year they are admitted 10. Last 2 months ago, actually entered 42 new judges in the system, but still is very much a low number compared to what the needs are as well. The salaries of the judges have been increased. However, the number of cases that judges now have to handle is way more than it used to be before.
Yes, definitely challenging. The Are there any issues that you would highlight in terms of the judiciary that's not covered here? I think what we covered is the resources and the essentially capacity issues created by, assuming that the corruption issues have been solved. So capacity issues, is there any institutional challenges that you would reflect on, whether it's about the choice of how decisions are made in terms of judicial governance or otherwise? There's a judicial council model. How does it work, and how has it played out for Albania in this sense?
Sure, Nina. So the Judicial Council has 11 members currently. It's the same composer, I would say, similar to the Montenegro one. There are 11 members of Judicial Council. 6 are chosen by the judges themselves, members, and 5 are elected by the parliament. And these 5 that are elected by the parliament are from non-members of the judiciary, should be usually lawyers who have an experience of 15 years or more, and mostly are coming from the civil society part. And the head of the Judicial Council should come from these 5 members that are elected from the parliament. Even though the head of the Judicial Council doesn't have anymore the right to be re-elected because there is a mandate for 5 years. The problem is that these 5 members that are elected by the parliament do not go through a background check or assets verification as judges or other members that are elected from the judges are going through. And this is problematic because it comes to the issue of the meritocracy, but as well how these people are being elected, nominated, and elected later on. And this has been as well demanded by the European Union, and it is a draft law currently proposed at the Albanian parliament to reinforce and make background checks and asset verification of these 5 members of the Judicial Council who are coming from the non-judiciary members, from the outside judicial system. Another issue that I would say as well is related to a bit to the vetting. The members of the judiciary who went out of the system from the vetting process who could not justify their asset declaration are coming from the back door as lawyers in private practice, or even badly, as some of them are even being lectures at the School of Magistrates. So the ones which are like the new generation of judges is being taught by some lectures who have not been passing the vetting process.
I can see that that's quite yeah, we might end up in the circle of kind of coming to the same place through this process. Thank you very much, Arlene, for your very detailed and data-dense reflections. I think we have some questions already in questions and answers. Some of the earlier questions are directed to Bojana. One group of questions has to do with the data on public perception and trust in the judiciary. If you have any recent data that's reliable, and also the distinction between the public perception, general public perception, and perception of court users. So the people, you also highlighted that a lot of people now have more experience with the actual system, so this colors their understanding of how the system works. Could you reflect on those two things, please?
So the second thing is that Arlene actually also talked about it, because people are having a lot of are getting a lot of civil cases, not like really criminal, but they have the experience of how long these cases are actually lasting. So, for example, we have situations in which citizens are approaching to us because they don't know how to end some civil proceedings in the court, or they don't understand why is it lasting so long. So they ask for our help to take a look into the personal case. It could be, like case, like civil complaint with neighbor, or, but they have, this is the experience they have, and they see that mostly because of the resources, the cases are lasting really too long, and it makes people angry because they cannot, they feel that justice is not fulfilled. But also there are some, I think, especially for example, in this situation, in Serbia, there are some cases that are really important for the public in general, and that are actually making the picture of how the judiciary is in a big, huge problem and under huge influence. For example, just one example is that we had this case it was still investigation against some group of people that attacked students on the street and beaten them. And there are some videos showing the whole event, what was going on. And one of the students, she got really hurt. So her jaw was dislocated because she was beaten by the bat, for baseball bat. And we have the case that prosecutor who is prosecuting the guys, who is leading the investigation, is a guest in some TV show in the television that is under the influence, pro-government television, basically. And he is asking for the president of the country to pardon the guys who are under investigation, which is totally the situation that, it's not understandable for normal people, that you have the prosecutor who is prosecuting, and his job is to prosecute. I don't know, maybe he can, stop the investigation or do whatever he can with the investigation if he doesn't find enough evidence to bring them to court. But asking the president of the country to act and to pardon the people who are under investigation is totally insane situation. And that happened. So after that, the president pardoned the guys. And so this is the current case that is so obvious obviously showing the political influence, and how we have like really we have part of the judiciary who are really people who are really under the influence. Then we have part of the people who are criticizing what's going on, and they're becoming targets. So then the pro-government media are starting smear campaigns against them and trying to frighten them. They cannot be they are also like they have problems at work. They cannot progress to better position inside the court or inside the prosecution. And then the third part, and I think that's majority currently, is that people are afraid. The part of judiciary who are like people who are afraid, who are silent, and who are only waiting for this situation to end in any way, so they can know what position to take. But basically, people are seeing what's going on, and yes, they have personal experience, and that is what Arlene said. Like it's similar, it's the same practically as in I think most of the countries here in the region actually. And what was the first question? Sorry.
I think a public trust issue you covered. I think you also covered another question that I didn't raise was about tracking actually the prosecutors and judges that speak out, if there's any way. And I understand that you are tracking these instances as well and have them in mind when you are covering. So essentially those who are speaking out and have consequences. I really want to ask Arlene this quick question, and maybe we come back to you if we have time on this, but you have largely covered the issue. Arlene, the question was about whether the vetting, for example, in Ukraine and Moldova is something of a EU demand or something that's publicly, so bottom-up demand. What is your kind of observation on that? Do you have an opinion? Whether it's something that's to kind of something to check out of the list, or it's something that's supported by citizens locally.
Yeah, thanks, and thanks, I think, to Theodora. Thanks for the question. So, in public or in the European Commission did not somehow support the vetting process or went out and encouraged the vetting process as a process to fight the corruption. So in the enlargement progress reports, we have seen that both countries, Ukraine and Moldova, have made substantial progress. But when it comes the vetting process, I don't think it has been something that the EU has required. If it is supported by the local citizens, both countries have very much other outstanding issues that they have to deal in Ukraine. The war situation, and in Moldova as well, has been very much a foreign interference. But there is as well a difference between the two countries. While in Moldova has been an international monitoring mission when it comes to the vetting process, it somehow, for the local perception or how it has been supported by the local citizens, it really as well even blocked the functioning of the Supreme Court of Moldova for a long period of time, the vetting process, because it didn't reach a quorum in order to constitute and to composure of the Supreme Court. So really it was a challenging issue, even though it has been moving a lot in the last 2 years. But still, I would say, and when it comes to the benchmark checks needed in the process, both countries currently are not decoupled in the EU process. And they have gotten very much assurances by the European Commission that once the Hungarian veto towards Ukraine will be lifted, both countries will be opening chapter 23 and 24 in the first cluster of the fundamentals with the European Union.
I see. Thank you. I wanted to ask Pavel how, because I want to leave you enough time. We have some other questions, but I really want to leave enough time to talk about the blog. So if you want, you can step in and tell us about it so that we also finish. Thank you everyone for the questions. It was really fascinating, I think, and this for the speakers. Yes, Pavel?
Yeah, thank you very much. It will not take long. It's good that we have a few more minutes, so I'll jump in, and then maybe there will be a little time also to ask one or two more questions. I'll just share my screen and show you. Well, showing it's, I think, more interesting than talking about it. Do you see the blog on your screen?
We do, yes.
Yes. So it's actually not much to tell. It's a blog that we called Law and Governance in Southeast Europe. The URL is lgc.blog. It's also easy to remember. And the purpose of the blog is actually to offer a platform for researchers and practitioners from the region, Southeast Europe, to readers from actually all over the world, but specifically from the European Union, from Germany, from Brussels. And the idea is actually to offer articles, short articles, well, block lengths up to 2,000 words, to try to make it more accessible. So same purpose as the hub, not to make the language too complicated. So also journalists, for example, but also decision makers can read. And we have come up with different categories. We just launched it 1.5 months ago, so it's very young. And of course, there will be more development here. And, if you want more information, you can just get here to about. We have already around 15 articles, I think, on different topics: governance, administrative law, constitutional law, technology, European law, post by country. So you have from almost all the countries here already. We also present our projects here. We have an experimentary chapter, which is AI podcasts, where you can already listen to some of the productions here. But it's just, well, we're just trying around and see how it works. If it works well, we will continue with this. We have a cooperation for now with Pravnik Association from Bosnia and with Icon S, Balkan division. Some of you know probably Icon S. It's one of the big organizations on public law who are organizing big conference every year, but also have lots of research. So what's actually the most interesting and important for you is the invitation to submit contributions here. And in order to see what we expect, you can just check our submissions chapter here, where we describe actually what we expect. So information for authors, topics we're interested in, style and content, and how it should look, sources, citations. We expect the scholarly quality here, so academic rigor, but at the same time, understandable language. And if you just click on the articles that we have, you will see actually how the styles and the depth of the articles. Normally we deal with just one or two legal problems. It's not about being as broad as possible. It's rather being as short and as deep as possible. So discussing one or two problems that are very particular, very specific, with footnotes, with sources. So this could also be maybe a short version of some journal article, for example, written in a little bit easier language to understand. So we already have around a dozen of authors. So we welcome more authors. Also, if you want to cooperate, maybe as a member of the editorial board, or also as a partner, or you think your organization would be interested in partnering with the blog or a link exchange, we are very happy to do that. And yeah, it's if you have any questions, you are welcome to ask. But I think I'll stop here and leave it to Nino now to get back to the.
Yeah, thank you very much. It's very interesting. I think it's the more knowledge and analysis we have, the better. And we saw from the questions also that there is a need for discussion and for analysis. Unfortunately, we cannot go back to some of, we could probably speak a lot more about the questions that were raised and ask more questions. However, today, I suppose we'll close. I want to thank you, thank obviously Konrad Adenauer Stiftung to make this possible, this expansion of the hub, and thank our fantastic speakers for being with us, for sharing their reflections. And I very much hope that we remain in touch and have other opportunities to discuss these issues and continue our work in our respective fields and sectors. Thank you very much. And yes, out to our audience, obviously, and hope to see you soon on another occasion.
Thank you.
Thank
Thank you, Nina.
Thank you very much.
Thank you, everybody.
Thanks.
Thank you.